Hi there. Today I want to tell you about a decision that just came out from the Supreme Court in a case that we at the CCF intervened in. The big question in this case, called R v Power, was, can you sue the government for damages, for money, for an unconstitutional law? Now, the shocking thing about this case was that the federal Trudeau government was arguing that they had absolute immunity from being sued by people who were hurt by their unconstitutional laws, even after courts had struck down those laws as unconstitutional. The government in Ottawa was saying that people hurt by those laws can never sue. We had argued as an intervener that there is no absolute immunity. And I'm happy to tell you today that the court sided with us. I can't wait to tell you all about it. If you're new here, welcome. My name is Christine and I'm the litigation director at the Canadian Constitution Foundation, a legal charity that fights for fundamental freedoms in Canada. I upload regular videos about our ongoing legal cases and about other interesting developments in constitutional law in Canada. So if that sounds like something you'd be interested in, please hit like and subscribe below. It really helps my videos out a lot. Also, please remember nothing in these videos is ever legal advice. If you have your own legal question or problem, please consult your own lawyer. So as I said, this case is called R v Power. I'll leave a link to it in the description below. And the main issue in the case was this question of whether you can sue the government for an unconstitutional law. Now, it's important here to distinguish between suing the government for an unconstitutional law, which is what's proposed here, and suing for unconstitutional acts by government state agents or the executive. So we're all familiar with lawsuits for, say, police brutality, or even the ongoing lawsuit right now for the executive action, harm caused by the executive action of the Trudeau government freezing bank accounts when they declared an emergency under the Emergencies Act. Now, you can sue for damages for that. You can sue for damages for executive acts or acts by state agents. That's well established. But what if you have damages flowing from the law itself? That is what Mr. Power, in this case, said he was suffering from. So this is the difference between suing for an unconstitutional law and suing for an unconstitutional act by a state agent. So in Power's case, he had been convicted of criminal offenses in the 1990s. He served his time and he became an X-ray technician. He looked into getting a pardon for those criminal offenses, but by the time he got around to applying for his pardon, the regime for granting pardons had changed, and there was now this new federal law that prohibited him from getting a pardon. Now, this regime actually applied retrospectively. So even though at the time of his conviction, he would have been eligible to apply for a pardon after 5 years, now because of this new law, he was permanently ineligible for a pardon. And it eventually came out to his employer that he had this criminal record, that he couldn't get the pardon, and as a result, he was let go from his job. Now, eventually the law that was preventing him from getting that pardon was struck down as unconstitutional. But by then, he'd already lost his job and his income. So he wanted to sue the government for damages for that law that had been found unconstitutional. And the question that went to the Supreme Court in this case was, can he? Can he sue? Now, this is not an entirely novel question, even though it's different from suing for executive acts or acts of state agents. This is still not a new question. There's existing case law, a case that's about 20 years old called Mackin, that says that you actually can sue for an unconstitutional law if a high threshold is met. So you can sue for an unconstitutional law if that law was enacted in bad faith or as an abuse of power, or if it was clearly unconstitutional. Now, that's a high threshold that Mackin set out, but it should be a high threshold. Governments can't govern effectively if there is a permanent specter of liability hovering over every single policy decision that they make. On the other hand, governments shouldn't be immunized from just trampling on our constitutional rights in bad faith. And I think that the court got it right in Mackin, and that had been the law for about 20 years. We haven't seen the floodgates open with this, tsunami of litigation bankrupting our country. The court just in this case affirmed the standard for Mackin, which I think is good both for accountability, but also good for stability of the law. Now, the court in this case affirmed Mackin. They found that the Constitution must be read so that the key principles are reconciled with one another, not read reflecting some hierarchy in which one principle is subordinated to another. The court explained that constitutional remedies must reflect a balance and must take into account government accountability. And the government concluded that a limited amount of immunity, rather than absolute immunity, best achieves that balance. It considered these various principles like parliamentary sovereignty, parliamentary privilege, and the separation of powers, and found that those principles are not in conflict with this limited immunity. Now, the majority concluded that while our democracy requires the preservation of an independent space for elected representatives to carry out their parliamentary duties, which includes debating and deciding our laws, they found that absolute immunity would actually subvert the principles that ensure government accountability, namely the rule of law and the court's role in ensuring compliance with the Constitution. So that is essentially what we at the CCF had argued, that allowing for the ability to sue in some limited cases for unconstitutional laws is actually necessary for accountability. Now, that threshold, bad faith, clearly unconstitutional, or abuse of power, is this threshold that needs to be met if you're going to sue for an unconstitutional law. And the majority did some work trying to clarify what those terms mean. It said that mere negligence wouldn't be enough to overcome the immunity. We had also argued that negligence wouldn't be enough. And instead, the court found that a law would need to be clearly unconstitutional in the sense that the state either knew that the law was clearly unconstitutional or was reckless or willfully blind as to its unconstitutionality. Now, the federal government had argued that this standard of bad faith and abuse of power should just be thrown out, and the majority rejected that. They declined to throw out or discard that part of the test, but they didn't, provide a huge amount of clarity about what those terms actually mean. So what about Mr. Power? Can he sue? Well, the court said that he can try, and I'm not convinced that his case meets that threshold of clearly unconstitutional abuse of power or bad faith. But the Supreme Court said that he can try. He might not be successful. But what kind of cases might meet that threshold? When this hearing happened, there were a lot of hypotheticals discussed, but we actually don't even need to talk about hypotheticals. We can look at some real examples from Canada's own history, because we have a history of enacting unconstitutional laws that the enactment of the law itself can harm people. The laws that interned Japanese Canadians into camps. There was laws banning Indigenous potlatch ceremonies. There were laws that had forced sterilization of Indigenous women. In fact, there are damages that can flow from these laws, even if government action by state agents or the executive is not yet taken. So let's look at the example of internment camps. The legislature might pass a law saying people of a certain ethnicity are sent to an internment camp, and people of that ethnicity may take action in response to that clearly unconstitutional or abuse of power law. They may relocate. They may sell their possessions. There are damages to those people that result from the law itself before the executive part of government even takes action. Or consider legislation that existed that related to forced sterilization. If the legislature were to do that, if they were to pass another law like that, people, again, who are subject to that law, they might move, they might go into hiding, they may preemptively do things to their bodies to preempt the state from taking action. And there are damages that flow from the enactment of those clearly unconstitutional laws. Let's consider another example. I've talked about this one in a previous video I did about this case. There's something called a bill of attainder, and these used to get passed in England. These are acts of the legislature that declare a person or a group of people guilty of some crime and punishing them without a trial. So a bill of attainder might say, Christine, she's a very bad person. No one should speak to her. No one should employ her. She's a pariah. We should give her the death penalty even. So, you might be thinking bills of attainder, those are these old things from England. This is an irrelevant hypothetical, but Parliament in Canada has twice tried to pass bills of attainder. I mean, not to people like me. They were passed bills of attainder against some two notorious serial killers, but they still tried. So you might think that because these are, serial killers that they tried to pass bills of attainder related to, that those are not, good examples. But the simple fact is that this is not how our system is intended to work. We should be concerned when governments have a history of passing laws that are abusive or in bad faith. This is a high threshold. Like, how would you feel if Parliament passed a law specifically targeting you or targeting one of your political enemies or someone who may be unpopular in the mainstream, but who, for whatever reason, you happen to like? The government has shown in our living history that they have a willingness to pass specific laws targeting individual people. If they're willing to do that, I think that we need some type of recourse to prevent that from happening. I want to come down on the side of limiting the government's power to do this. The state should not be entitled to this absolute immunity from claims of damages. And individuals should have a right to sue, I think, when that high threshold in Mackin is met. And the Supreme Court has now affirmed this. Now, the thing that is interesting about this case is this tension or relationship maybe between competing constitutional principles. There's the legislative autonomy, the autonomy of Parliament to pass these laws, and then there's legislative accountability. What recourse do we have as citizens when governments enact laws that are abusive or in bad faith or clearly unconstitutional? So by legislative autonomy, I mean this idea that Parliament is sovereign, Parliament controls its own process, that the judiciary and the legislature are separate, that the legislature makes the laws, that's their function, and the courts interpret the laws or strike them down, but they may not overtake Parliament's independence to make those laws. And there have been some critics of this case who have said that this power case is now that's what the courts are doing now. They're overstepping and overtaking Parliament's independence to make laws, even unconstitutional laws that are in bad faith. Now, the other set of principles are legislative accountability. So constitutionalism and the rule of law, these are fundamental principles that guide the courts and Parliament. When these principles are violated, I think that there must be accountability. And look, I am on the record as a skeptic of judicial power. I think that judges have very different lives from the rest of us, and judges get it wrong. And sometimes judges are overly ambitious and overly want to intrude into the policy making realm that should be the sole responsibility of Parliament. And I understand, some people are saying that this case is undermining Parliament's power and supremacy. But as you all probably know, I'm also a skeptic of power generally. I'm not just a skeptic of judicial power. I'm a skeptic of Parliament and of politicians. And I don't want them to have unlimited immunity the way the Trudeau government was proposing they have here. For those people who, like me, don't trust judges, I agree. But I want to know why you would trust politicians with unlimited immunity. Allowing these limited situations where people who are badly hurt by clearly unconstitutional laws that are enacted in bad faith or are abusive, allowing them to sue for damages is, I think, a reasonable check on that power. And it's consistent with the principles of constitutionalism and the rule of law. You know, our politicians are not some noble philosopher kings. We should not trust them with the amount of power and immunity that they were asking for in this case. And I think we at the CCF came down on the right side of the issue, limiting state power to hurt citizens. And I think that the Supreme Court in this case got it right. Now, I would love to know your take on the issue. Leave a comment below letting me know what you think of the case. I'll link to the decision below. If you're interested in this case and other cases like it, make sure you sign up for our email freedom updates at theccf.ca/freedom updates. Okay, that's it for this update. Thanks for watching, and let's keep fighting for freedom in Canada.